The next matter to come before the court is Omni Proverb Twinsburg versus GameonBusiness and Sweepstakes Center.
Good morning, Your Honors.
And it looks as if the appellants have belatedly waived oral argument,
That's correct.
and so you will have 15 minutes to present your oral argument.
Thank you.
We have read the briefs, and so we're prepared to go forward when you are.
Thank you, Your Honors. May it please the court. There's only one contract that this court should be reviewing, despite the appellant's red herrings to the contrary. And that contract is the guarantee. The duties of the contract...
I'm sorry, I may have missed it, but I did not hear you introduce yourself.
I'm sorry, Your Honor. My name is Greg Arfinko. I represent the appellee Omni Proverb Twinsburg LLC. There's the guarantee and the lease agreement are two separate and distinct and independent agreements. The contract before this court is the guarantee. The duties of the contract are independent of the promises made in the guarantee, as well as the principle of the lease agreement, or the tenant of the lease agreement, is Gameon. Gameon is not a part of the guarantee and did not sign the guarantee, as well as Mr. Salzberger and Mr. Barman did not sign the lease agreement and are not a part of the lease agreement. The main issue before this court is whether there was a breach of the guarantee. And we would respectfully say there was a breach of the guarantee based on the judgment entry of the trial court dated July 25th, 2014, which conclusively determined that the tenant, Gameon, breached the lease agreement. And the court conclusively determined that the guarantors are now precluded from relitigating that issue because it had already been determined by the court almost 2 years ago.
When you say that they're precluded from relitigating the issue, you mean the issue of the lease agreement?
Correct.
Okay.
And that's because the court had already determined that there was a breach. No one appealed that decision. That decision's never been objected to or reversed, and that decision still holds today. So Mr. Barman and Mr. Salzberger consistently try to tell the court, both the trial court and here in the briefs, that the tenant did not breach it. They consistently try to raise defenses for the tenant. However, again, there's already been a breach of the original agreement. The guarantee specifically states that the guarantors also guarantee the payment to the landlord of any monies payable by tenant under any provision of the lease, at law or in equity.
Now, Barman and Salzberger were parties to the complaint that was filed by Omni, correct?
That is correct.
And so they were a part of the litigation, and they filed answers.
That is correct.
Whereas the corporation did not, and the other gentleman whose name escapes me.
Mr. Del Toro, James Del Toro.
He didn't. So your client was rendered a default judgment. So when it comes to the filing of the motion for summary judgment, no one raised the issues related to the lease, is that correct? Or were they permitted to, I guess is the question.
They discussed the provisions of the lease in their opposition to the motion for summary judgment. So the trial court heard all of their arguments and again said, you cannot relitigate this matter because there's already a breach.
So really, there was no way for them as guarantors to protect themselves, except, I guess, through their relationship with Del Tordo. And once he defaulted, they were just on the hook for whatever the damages were.
They were on the hook based on what they signed in the lease guarantee.
Did you say were or were not?
I would say they were on the hook for the breach based on the judgment against Gameon.
By virtue of their guarantee.
By virtue of the guarantee, yes, Your Honor. And specifically in the guarantee, they waived all defenses that could have been raised by Gameon. So any attempt to relitigate or rehash any defenses that Gameon could have raised, they failed to do that. And the guarantee prohibits that. Just to summarize, what we have here is a judgment against the tenant in this matter, Gameon, based on the breach of the contract. The complaint in this case, in counts 2 and counts 4, against Mr. Barman and Mr. Salzberger respectively, was solely based on the breach of the lease guarantee. It wasn't based on the breach of the agreement.
Counts 3 and 4, you said.
Counts 2 and 4. Yes, based on the guarantee. So once the trial court issued a judgment against Gameon, then automatically, based on the provisions of the lease, they would be responsible. Mr. Barman and Mr. Salzberger would be responsible for the payment to Omni. If this court has no further questions, I would respectfully ask that the trial court's decision be affirmed and the judgment in the amount of $53,878.34 plus the attorney's fees of $13,000 plus the cost and interest of 12% be affirmed.
Thank you.
Thank you.
For your presentation. The court will take the matter under advisement. We will issue a written opinion which will be sent to both sides, and do check the Supreme Court website as we post our decisions there.
Thank you, Your Honor.
Have a good day.
You too, thank you.